Professor Ian Waters is here with us tonight. He holds degrees of Master of Church Administration, a licentiate in Canon Law, a Doctor of Philosophy, Canon Law, from the University of Ottawa, and Doctor of Canon Law at St Paul's University in Ottawa. I said to Ian I wouldn't go through all of these things because it would take too long. He is the Emeritus Judicial Vicar, Presiding Judge of the Catholic Tribunal for Victoria and Tasmania, and he has over the years chaired the Melbourne Diocesan Historical Commission and is a diocesan censor of the Archdiocese of Melbourne. He has been a director of Calvary, or is currently a director of Calvary Ministries. His academic interests are in research associated with the following bodies: the Canon Law Societies of Australia and New Zealand, of Great Britain and Ireland and of America, Corpus Christi Priests Association, Brisbane Catholic Historical Society, Australian Catholic Historical Society, Malvern Historical Society. Now, why is all of that important? It's important because it puts these people and their background into the context of all that we're going to hear tonight. He's also published pieces such as the Fourth Plenary Council of Australia and New Zealand and an item in the Australasian Catholic Record, General Absolution, Where Are We At? And when he has spare time, he is also the parish priest at St Roch's Glen Iris and St Cecilia's in South Camberwell.
At the outset, I am Ian Waters, and I'm here in the capacity of a private person. I've not been authorised to speak here by any Catholic Church authority, and specifically I'm not speaking with any mandate from the Archbishop of Melbourne or the bishops of the Ecclesiastical Province of Victoria and Tasmania or the Australian Catholic Bishops' Conference or the Holy See. I was ordained a Catholic priest in 1970, commenced graduate studies in Canon Law in 1973, and have been a canonical practitioner since then. I hold the academic rank of Professor at the University of Divinity, where I have lectured Canon Law since 1991. In summary, I believe I'm qualified to speak this evening, but I'm not speaking on behalf of the Church. And I'll try not to go over the half hour. In fact, I'm sure I won't. Some time ago, I was advised that Kieran's views and arguments he adduces in his book Potiphar's Wife, The Vatican's Secret and Child Sexual Abuse is on public record, and he was interested in what I would regard as errors or flaws in his analysis as a basis for our discussion this evening. This evening's topic, as you know, is the role of church law in child abuse, in the child abuse issue, help or hindrance. I take no issue with much of what Kieran has written in Potiphar's Wife. However, as a canonist, I cannot accept a number of assertions given as facts. And these, as far as I am concerned, make much of what he concludes about the abuse crisis in Australia and about the actions of Catholic bishops, and what he concludes about what popes decided and decreed personally, quite problematic. I've got here 5 headings. One is Australian Catholic canonical background. Second is canonical documents. The next is Latin. The next is secrecy. The next is the privilege of the clergy. And there's some minor points at the end before I wind up. Can
you speak up, please?
Should this be amplified or what? Australia was classified by the Holy See as a missionary territory until 1976. Consequently, Australia did not receive from the Holy See all the general correspondence and circulars that non-missionary countries received. I believe that this is the explanation of why no copy of Crimen Solicitationis, either the 1922 version or the 1962 reprint, has ever been discovered in any archive in Australia. It simply was not sent here. The bishops and other ordinaries and missionary territories do not deal directly with the individual departments, known by terms such as congregations, at the Holy See. Instead, all business and dealings are channelled through the special department that deals with the missions. It was formerly known as the Congregation for the Propagation of the Faith, but in recent decades it has been known as the Congregation for the Evangelisation of Peoples. At the Congregation for the Propagation of the Faith, the Cardinal Prefect, often referred to as the Red Pope, and other officials dealt with the vast majority of matters themselves. A minority was sent to other departments for advice or opinions, and then referred back to the Congregation for the Propagation of the Faith for resolution and returned to the originating bishop. Moreover, the missionary territories were conceded special privileges and faculties that exempted them or dispensed them from the general canon law of the universal church. It would take me a long time to list them all, but they were as varied as bishops having to report to the Pope each 10 years rather than each 5 years, Catholics having to observe only 5 instead of the 10 holy days of obligation, bishops being able to grant dispensations from certain obligations of canon law that were reserved to the Pope, and cases in ecclesiastical tribunals being able to be judged by a sole judge instead of a bench of 3. Even after 1976, these faculties were able to be used until 1986, as the Holy See, in removing Australia's missionary status, decreed that the missionary faculties could be used for a further decade to permit a non-traumatic transition for us having to function normally under the Code of Canon Law. In summary, until 1986, the Catholic Church in Australia did not function as it did in Europe and North America. Instead, we functioned as it did in, for example, the African countries. Consequently, writings of canonists from Europe and the United States may reflect accurately what happened or did not happen there, but do not reflect fully the Australian situation. I first heard of Crimen Solicitationis on the 17th of September 2002 during a paper delivered at the annual conference of the Canon Law Society of Australia and New Zealand, being held at that time in Christchurch, New Zealand. The paper was by the keynote speaker, an experienced canonist from the United States. I commenced canonical studies in 1973, and I have 5 canonical academic degrees. I formed the impression that this document was also news to the 101 other conference delegates. Whatever of its transmission to other countries, it was obscure and unknown to us in Australia. Some comments on canonical documents. It seems to me that Potiphar's wife takes no notice of differences between the various canonical documents. There are real differences between apostolic constitutions, apostolic letters, motu proprios, decrees, instructions, notifications, directories, etc. The type of document chosen always indicates its author, relevance, purpose, and whether it's legislative or not. Briefly, an instruction is not a law. It was defined by Pope Benedict XV in 1917 and is described in Canon 34 of the 1983 Code of Canon Law. Crimen Solicitationis was a mere instruction on how the penal law process, Canons 1925 to 1959 of the 1917 Code, was to be applied to some, but not all penal cases, specifically those dealing with certain very grave crimes committed by clerics not laypersons, namely solicitation in a confessional, homosexuality, pedophilia and bestiality. In other words, crimen solicitationis was a series of norms or guidelines for the internal use of any tribunal that ever had to process such a case. Instructions are not normally published, as they are not laws, but merely regulations or guidelines to help those executing the law. In fact, no legislation can take effect until published according to the required canonical process, and normally in the Vatican journal Acta Apostolicae Sedis, which is the church equivalent of Hansard. The signature on a document indicates its importance and nature. Just as there is a difference between a document signed by the Governor-General or Prime Minister on one hand and a senior public servant on the other, there is a parallel between a document signed by the Pope and one signed by a Vatican official. The legislation regulating penal law from 1917 until 1983 was the process contained in the 1917 Code of Canon Law at Canons 1925 to 1959 and Pope Benedict XIV's Constitution Sacramentum Penitentiae dated the 1st of June 1741. The law since 1983 has been the process Canons 1717 to 1731 in the 1983 Code of Canon Law. The instruction of 1922 and its reprint in 1962 have contained norms to try to facilitate the implementation of the penal law in these specified crimes committed by clerics. The law must be followed for a valid process. In my opinion, and that of most reputable canonists, non-observance of articles of a mere instruction would not invalidate the legal canonical process. The 1917 Code of Canon Law was issued and signed under the signature and letterhead of Pope Benedict XV. In contrast, Crimen Solicitationis was issued in 1922 on the letterhead of the Congregation of the Holy Office and with the signature of Cardinal Raphael Mary del Val, Secretary of the Holy Office. And the 1962 reprint was issued from the same office with the signature of Cardinal Alfredo Ottaviani. In this diocese, if I received a circular letter signed by the Archbishop, I know before I read it that it deals with a very important matter and is meant to be taken much more seriously than a circular issued from a diocesan official such as the Vicar General or the Director of Catholic Education. I understand that Cardinal Joseph Ratzinger, when prefect of the Congregation for the Doctrine of the Faith, that is, before he became Pope Benedict XVI, asserted that Crimen Solicitationis was in effect until 2001, when replaced by the norms attached to Pope John Paul II's legislation Sacramentorum Sanctitatis Tutela. That was clearly his opinion, which, in my opinion, was misguided. Ratzinger certainly had a doctorate in dogmatic theology, and he had what the Germans call an habilitation, and the Americans call a higher doctorate, to qualify him to be a university professor. But he had no qualifications in canon law and should have been briefed by reputable canonists before making such an assertion. In my opinion, he could only have given advice such as, "We have no instruction at present to elucidate the penal process in Canons 1717 to 1731, and until it comes, it may be useful to follow, mutatis mutandis, the norms of Crimen Solicitationis, which was an instruction to elucidate the 1917 Code, not the 1983 Code." I'll say something about Latin. Official church documents are always in the Latin language, and translations into the major modern languages are made from the Latin text. As regards the mentioning of secret archives, the Latin text has the word archivum secretum, often translated as secret archive. It should be noted that the Latin word secretum is translated in various dictionaries by other words in addition to secret, including separate, apart, remote, solitary, private, hidden, concealed. In Latin, secretus is the past participle of the word secerno, which means to put apart, to sunder, to sever, to separate. I personally would consider that the archivum secretum is most accurately translated as confidential archive, in the sense that it's separated from the normal archive to which many persons can gain access. I do not believe that the words can be translated to imply something secretive or a means for covers-up. The Catholic Church is not the only entity in Australia with confidential archives or classified material or restricted access or in-camera sessions. The reasons are not usually presumed to be cover-up. Incidentally, the Latin word secretarius, translated as secretary, was the person overseeing business confidentially, not secretly, for a powerful person such as a king or a pope. As the duties of the modern secretary often still include the handling of confidential information, the literal meaning of secretary still holds true, but no one expects a secretary to be secretive. Now on secrecy itself. The highest and only absolute form of secrecy in the Catholic Church is the secrecy of the confessional. Pontifical secrecy, until 1974 called the secret of the Holy Office, is regarded by canonists, whatever of others, to mean greater than normal confidentiality. It's paralleled outside the Church with concepts or conventions such as cabinet confidentiality, diplomatic confidentiality, boardroom confidentiality, in-camera hearings, military secrecy, and professional secrecy, which is observed by professionals such as doctors and lawyers with their clients. Pontifical secrecy has never been regarded as absolute, as confessional secrecy is, but there are penalties for infringing it without sufficient cause, as there is with infringement of the other secrecies listed here. Most canonists would see secrecy as attempting to protect the victim, the accused and the witnesses so there can be a free finding of facts before a verdict is handed down. Now, the privilege of the clergy. I'm not going to try to defend privileges that were accorded the clergy in many places when Europe was synonymous with Christendom, other than to make the observation that what seems archaic at the very least now often was based on what was accepted as valid premises in the past. But leaving aside clerical attitudes and clericalism that may still prevail, especially in Europe, clerical privileges have never existed in Australia for two reasons. The first is that there was no provision for it in the missionary canon law that governed Australia until 1986, as already explained. Secondly, civil law in Australia, inherited from the English common law, has never accorded the Catholic Church juridical personality. That's the legal reason why the Church, as such in Australia, cannot own property. Instead, she has to arrange for a civil law entity such as a trust corporation to hold its assets, as was made clear to all at the Ellis case in Sydney. Some countries whose legal systems permit it have entered into legal arrangements with the Vatican known as concordats, and some of these have accorded special privileges and exemptions to clerics. But it's simply absurd, in my opinion, to suggest that such arrangements have or can in any way affect how the Church is run or has conducted itself in Australia. Some other points. As regards the oath of fidelity to the Apostolic See required of bishops before ordination, most commentators see this as ensuring the unity of the College of Bishops rather than subservience to the person of the Pope. In Australia, all police officers take an oath or make an affirmation that I will well and truly serve our Sovereign Lady the Queen as a police officer. I will see and cause Her Majesty's peace to be kept and preserved. I suggest that does not make police officers subservient to the person of the Queen. Nor does the oath or affirmation of allegiance taken by our members of Parliament. I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth, her heirs and successors according to law. Another point, it's not accurate to describe automatic excommunication as the Church's worst form of punishment involving expulsion from the Church community. An excommunicated person is still a full member of the Church community, albeit subject to certain penalties, specifically prohibition from liturgical ministry, from reception of the sacraments, and from exercise of any ecclesiastical offices, ministries, functions, or acts of governance. And so my conclusion. It's reasonable, in my opinion, to conclude that the Church in general, and certain bishops in particular, have been most inept, naive, and often unjust in dealing with the problem of sexual abuse of minors. It is, in my opinion, also reasonable to conclude that many bishops and others in the Church resorted, on their own initiative, to secrecy as an attempt to avoid embarrassment. But the canonical facts to which I have drawn your attention have to be considered before concluding to cover up. What has happened in Australia with sexual abuse and other types of abuse of minors by Catholic personnel, both clerics and non-clerics, is shameful. It's humiliating for the Church to have to face this mess. But my personal position is that it had causes other than canon law, that canon law cannot be blamed for it, and that it is to be remedied by means other than canon law. Thank you.